Hi, my name is Jonathan Culbertson, and I am the Senior Compliance Manager at InCheck, a background screening company. Welcome to the September 2024 edition of InCheck's Compliance Update Vlog. Now, the vlog briefly features some recent legal updates that affect background screening and the hiring process, so that you can take that information back to your teams and legal counsel for further review. Let's get started with some news from the Federal Deposit Insurance Corporation, or FDIC. The FDIC approved a final rule that updates the FDIC's regulations concerning Section 19 of the Federal Deposit Insurance Act to conform with the Fair Hiring and Banking Act. Now, as a reminder, Section 19 prohibits, without the prior consent of the FDIC, a person from participating in the affairs of an FDIC-insured institution if they have been convicted of an offense involving dishonesty, breach of trust, or money laundering, or has entered into a pretrial diversion or similar program in connection with a prosecution for such an offense. Now, the regulations, among other things, provide the following exemptions to Section 19's prohibitions. 1, exemptions for offenses 7 years or more since the offense occurred. 2, offenses for which the individual was incarcerated and it has been 5 years or more since the individual was released from incarceration. 3, offenses that the individual committed when they were 21 years of age or younger, and if more than 30 months have passed since the sentencing for the offense occurred. 4, offenses for which there is an order of expungement, sealing, or dismissal. And 5, certain de minimis offenses. Now, please remember, though, that the federal offenses that are specifically identified in Section 19 still require a minimum 10-year prohibition before the FDIC may consent to an exception. Now, that final rule takes effect on October 1, 2024. So if you're an insured depository institution, you'll want to take a thorough review and look over that final rule to ensure that your background screening policies and procedures are compliant. Now let's take a look at a fair chance law that recently took effect, and then a pay transparency law that's right around the corner, both in Maryland, by the way. On September 16th, 2024, Prince George County, Maryland's Access to Employment for Returning Citizen Act took effect. The act amended the county's Ban the Box ordinance and prohibited an employer from inquiring into or considering 1, nonviolent felony convictions where the sentence was completed at least 5 years ago, 2, misdemeanor convictions where the sentence was completed at least 30 months ago, 3, arrests that did not result in a conviction except where the result was probation before judgment. If the result was probation before judgment, it should be treated as a misdemeanor in relation to its consideration for employers. And 4, any arrest or conviction of an applicant for possession of cannabis or cannabis-related paraphernalia that does not include the intent to distribute, provided any sentence for such crime has been completed. Okay, now that pay transparency law. On October 1st, 2024, Maryland's wage range transparency law will take effect. The law requires employers to disclose in each public and internal posting for each position the wage range, a general description of the benefits, and any other compensation. Now, if a public or internal posting for a position was not made available to the applicant for the position, the employer must disclose all those aforementioned required information before a discussion about compensation is had with the applicant, and at any other time that the applicant requests it. Please do note that the requirements apply to positions for work that will be physically performed, at least in part, in Maryland. Okay, that'll do it for me for this edition of InCheck's Compliance Update Vlog. Please join me again next time for some more compliance updates. Take care.